We're going to go ahead and call the meeting to order. We have got a pretty full docket here. So without further ado, Diana, if you'd call roll, please.
Representative Berger,
Excuse me, here.
Representative Nemec. Here. Representative Obermuller,
Jerry, say hi.
Here.
Representative O'Hearn,
Here.
Representative Pendergraft,
Excused.
Representative Smith,
Here.
Representative Stivar,
Present.
Representative Wiley. Here. Chairman Brown.
Here. All right, committee, we're going to go ahead and start off. We are going to change up the role a little bit if Mr. Wester makes his way down here. I told him I would bring him up to number 2. If he's not here, then we'll just skip him. So what we've got, Vice Chairman O'Hearn, do you want to go over this, or do you want to just roll through Senate File 113 together as a committee?
Let's do it as a committee, it's
All
a
right.
committee bill. Let's
Yep.
go through it together.
All right, so committee, what you've got before you is Senate File 113. You'll notice the language on this is light and high-profile vehicle closures -2. That's because -1 failed on introduction on our side, so this was brought back by Senator Pappas and the chairman on the Senate side, as well as myself and the vice chairman. And you'll notice that the introduced bill compared to what we had is significantly reduced, and ultimately what the reduction is they reference, instead of going in and creating new definitions, we reference 24.1.108, and that is, I believe, reckless driving, but I will lean on the law enforcement experts to verify that that's correct. Basically shortened up this bill quite significantly for us. Is there any questions right now that people have questions on, and if you don't remember the bill or anything like that, for myself or the vice chairman? Committee feels good?
Seeing none.
Okay, so we'll go ahead and bring the department up, and we'll have the department walk over anything that I may have missed. This is like I say, fairly simple bill, but Taylor, Misty, welcome. You just introduce yourself for the record. The floor is both for you.
Thank you, Mr. Chairman. Taylor Rossetti, Support Services Administrator. I think you did a very good job there, high level on what did occur. This was amended twice. In both instances, I do think it simplified the bill. We also did pass out a proposed amendment after consulting with the Attorney General's office. They had some concern about the second amendment to the bill. Really, it just comes down to trying to get it consistent with how some other statutes are administered. Real quick, looking at the bill, the first amendment to the bill was actually proposed by us. What it did was it simplified and it brought in 31.5.229, which is the reckless driving statute. That seemed to be the direction we were heading during the interim. We just couldn't quite get the language right. In between the interim and introduction of the bill on the Senate side, we were able to come up with some language. The second amendment then did go and added the language that you see there, really on page 2, line 17 through basically the end of the bill. The way that we look at this, and I think the way that it was really explained is it reduced the fine for the first offense to $1,000 from $2,500, which is where we were at with the original bill as proposed by the committee. And then it goes on to that your second offense for this infraction would actually then trigger into the reckless driving statute. So it's slightly more forgiving than the original bill was drafted and the amendment that we proposed. It does still seem very workable in our mind as the department. It still seems to meet the original intent of the committee as we went through the interim. With that, Mr. Chairman, I'd certainly stand for any questions, and Ms. Zimmerman here does have an explanation of the proposed amendment if you'll indulge us.
Okay, committee, any questions for Taylor? Okay, Misty?
Chairman Brown, members of the committee, my name is Misty Zimmerman. I'm the program manager for Driver Services. As we looked through the amendment that was proposed on the other side, we just wanted to make some clarifying language, and I believe that you do have a copy of what we are proposing in front of you. Our goal here was to strictly align with what other look-back statutes, how they read. The way that, when you look at on page 2, line 22, where it says, 1 year after the first offense. We feel that it maybe could cause some confusion going forward. What is that first offense? When was that first offense? After 12 months, do you start a new first offense? So what this language does is would strike the first offense on page 2, line 22, and add a conviction for a violation of this subsection. So it's very straightforward. It does align with most of our look back, or all of our look back statutes, and continues that language just into this section so that we can meet the intent and also understand what happens for that second, subsequent convictions.
Committee, any questions for Ms. Zimmerman? Seeing none, I have one. So the original discussion that I believe I heard, because I kind of listened to this on the other side, is you guys did not necessarily go after the 1 year. Is that correct? You guys, or was the 1 year look back, is that standard language?
Chairman Brown, members of the committee, the way that the original bill was worked was the reckless driving. And so that's actually occurrences within a 5-year period. And so the 1 year was actually proposed on the floor.
That's what I thought. Okay. So committee, well, we'll get into that here in a second on some discussion. Any further questions for YDOT? Yes, Representative Stivar?
Thank you, Chairman. Recalling this discussion, we're still going to go on, when we put the signs up, it's going to be by GVW, gross vehicle weights.
Mr. Rossetti?
Mr. Chairman, Representative Stivar, that is still our intent. And I think to carry that a little bit further in disclosure to you guys, there's still a little bit of concern out there as to which types of vehicles we're talking about and what can and can't go. There's the specter of the tanker truck. We've been adamant that the tanker truck, based on the science that we've seen, is not going to be included in this. There was also a discussion about belly dumps. We also believe the science does not support that those are covered underneath this. We do have some materials that are available that really show, and really what you're looking at is the straight-sided box trucks, normal semi-trailers that are lightweight. There's also the risk for, normal pickup trucks and stuff that are lightweight that are pulling. And I think the important thing for everybody to understand is, as this bill moves forward, as we do hope it does with all the work that we've done here as a committee, it's got a July 1 effective date. We are working through all of the systems. The messaging that you recommended or spoke of there, Representative Stivar, is the way we plan on doing this going forward. We do believe that the gross vehicle weight rating is a term that the commercial vehicles certainly understand. And those numbers as they're posted are generally numbers that are much higher than what a personal vehicle would be weighed anyway. So I think that communication is clear. We're dedicated to continuing communicating with the public. We have the commercial drivers portal. So on the commercial side, we do feel like there's an awful lot of education and opportunity for education for us as a department to clear up any of those issues. And just, I think, as it relates to your question, Representative Stivar, over a 4-day period last month, so the February 23rd through the 26th, we had 11 wind-related incidents on our highways. 10 of those were full blowovers, and 3 of those were actually pickup trucks that were pulling either a camper trailer or an unloaded or light cargo trailer. So again, I think our science and what we're seeing out there in reality does align very, very well. And again, we're trying to target those light, very high-profile trailers and trying to keep the traveling public safe, as well as reduce the amount of shutdowns that we have out there on our highways.
Okay. Follow up?
No,
Oh, you're good? Okay.
I got what I wanted, so
Okay.
the belly dumps.
Committee, any further questions for YDOT? Okay, thank you. And just, Misty, I want to make sure I did hear you. It's the current reckless driving look back is 5 years. Is that right?
Chairman Brown, I believe that is, but I'll confirm before we're done today.
Okay, thank you. Okay, thank you, guys. I think the other thing to mention here is the gentleman sitting back here in the green who spent numerous years out there on the road also has this little thing called discretion. And we give them that discretion to decide whether or not they need to file and write a citation for something like this. So any further public comment? Ms. Little, please.
Good Mr. Chairman, members of the committee, this is Kelly Little with the Associated General Contractors of Wyoming. AGC is in support of this bill, and actually, we are in support of the amendments that were made on the Senate side. My membership was a little uncomfortable with the strong nature of the penalties for the violation, so we feel like this is a great happy medium to come to, balancing the safety of the traveling public with the ability for businesses in Wyoming to recruit and retain trained and certified CDL drivers, which, as you all know, has been kind of a challenge recently. So we appreciate those changes and we support the bill.
Any questions for Ms. Little? Yes. Vice Chairman O'Hearn.
Thank you, Mr. Chairman. Have you seen the newest amendment?
Mr. Chairman, Representative O'Hearn, I haven't seen it, but just from listening, it doesn't seem like it's makes much change or any change in our opinion on the bill.
Okay, thank you.
Committee, any further? Okay, thank you, Kelly. Any further public testimony? I think we had Sheila online now. Okay, let's go ahead and open this up for Sheila, please.
I'll admit Sheila.
Oh, go ahead. We'll bring you up next, Josh.
Sheila just needs to turn on her mic and her video.
There she is. Hello, Ms. Furch. I received a
Good afternoon.
interesting email the other day. I hear you have some news for us.
Probably, if you want that now or afterwards.
Ms. Furch, it's up to you. The floor is yours. Just introduce yourself, please.
Mr. Chairman, Sheila Furch, Wyoming Trucking Association. Appreciate the flexibility of being able to join you virtually today. As you know, during the interim, we worked with you on this topic, and our biggest concern throughout the entire process was just that whatever penalties that we came up with applied to anyone, any driver, a CDL holder or a passenger vehicle, both Wyoming license holders as well as out-of-state holders. And throughout the process with the amendments, that remains. So that was the biggest thing that we were concerned about, just to make sure that whatever we were doing affected everyone who was disregarding these closures. As Ms. Little said, we're comfortable as well with the changes that were made on the Senate side. We had members that were okay with the really heavy fines and the reckless driving, and some that thought the fine was a little high. So implementing a lower fine for the first year makes sense to us. Bumping it up after a second offense seems like the appropriate way to go. To answer Representative O'Hearn's question to Ms. Little, I've not seen the amendment that YDOT proposed, but it seems very straightforward and I think would also be an improvement. I think it's important that when we do those lookbacks, we know exactly what time frame we're looking at. So that does make sense to us, and we certainly appreciate the efforts that YDOT has done. To take a little bit of information that Mr. Rossetti also brought forth, YDOT's done an excellent job of reaching out to industry. Even before we were talking about this bill, with the proposals they were doing on doing the targeted weight-based closures, they've been very, very proactive with us and advising us of message changing, the types of vehicles, how carriers can be more aware of what vehicles are approved and what aren't. We have a lot of members that use the commercial vehicle portal, and they're able to access that information. And we're happy to do whatever YDOT needs as far as getting that message out to our members, as well as surrounding state trucking associations, because it's their members that will be affected as well.
Okay. Thank you, Ms. Furch. Any questions for Sheila? Seeing none, congratulations on, I believe it's probably retirement. Is that correct?
Sometime this year, yes, Mr. Chairman. Thank you very much.
Well, congratulations. Thank you so much for joining us, Sheila.
Thank you.
Mr. Walther.
Mr. Chairman, Committee, Josh Walther, Lieutenant Colonel for the Wyoming Highway Patrol. I'll be brief. I think this bill's been refined and improved and should hopefully prove effective. We are supportive of it. Regardless of the change, to your point, Mr. Chairman, we do have discretion. Regardless of the fine amount or the changes in the bill or the law, we always try to take education enforcement first, or education over enforcement first. So we'll do that in this bill as well. So just wanted to state our support for it. I think it's a decent bill, and hopefully we'll move forward. And with that, I just stand for any questions.
Okay. Thank you so much. Yes, Representative Berger?
Thank you, Mr. Chairman, and Mr. Walter. Do you see, or in your experience, are we seeing more out-of-staters, especially with non-commercial vehicles, those lightweight trucks that are pulling camper trailers? Is it more of a out-of-stater vehicle or an in-state vehicle that's blown over? Where are you seeing that? Or is it just doesn't matter?
Lieutenant Colonel?
Mr. Chairman, Representative Berger, I would be speculating. I don't know off the top of my head which one's more. I know we see a pretty good mix though, especially when it comes to the cam trailers.
Okay. Thank you. Follow
Follow
up?
up?
And I agree. I appreciate your comment on education.
Okay, committee, anything further? All right, thanks, Josh. Any further public testimony? Okay, with that, we will close public testimony. Bring the bill back up to the dais. Committee?
Move the bill.
Moved by Stivar, seconded by O'Hearn. Committee, let's quickly walk through this. Nothing on page 1 unless we have something that somebody wants to change, but we do have a proposed amendment on page 2. Somebody want to move the proposed?
that amendment.
Okay, moved by O'Hearn, seconded by Stivar. That is for the proposed language on page 2, line 22, strike the first offense and add a conviction for a violation of this subsection. Any discussion? Seeing none, all those in favor, please signify by saying aye.
Aye.
All those, no? No? Okay, that is passed. Committee, anything further? Committee, I will propose then, I'm going to go ahead and try to stop doing and not have a conference committee on this, but I will say the 1 year is a difficult one, right? What I don't want to have is I don't want to have a trucker who drives cross-country coming through here once or twice a year. Comes through once 1 year, has it blow over, tips us up, costs us $8 million a day. Then they turn around and come back and do it again the following year. I think that there should be some consideration for that. So I would propose on line 22, moving that from 1 year. I'll split the difference between the 5-year that we originally had, and I will do 3 years. Any consideration?
Yeah, I'll move that.
Okay, so seconded by Berger. Any discussion?
Yeah.
Okay, Representative.
I forgot about that 5-year piece, and I like the 3 years. I do. And it makes a lot of sense to me.
Okay. Ready for the question?
Question.
Question called. All those in favor, please signify by saying aye.
Aye.
All those opposed, no. That passes as well. On to page 3. Anybody have any questions or concerns via the information on page 3? Okay, seeing none. Diana, if you would please call the roll on Senate File 113 as amended.
Okay, Representative Berger,
Aye.
Representative Nemec,
Aye.
Representative Obermueller,
Aye.
Representative O'Hearn,
Aye.
Representative Pendergraft has submitted an absentee vote of no. Representative Smith,
Aye.
Representative Stivar,
Aye.
Representative Wiley, Chairman Brown. That's 8 ayes, 1 no, and it do pass with amendments.
Okay, and since this is a committee bill, this is one of those that came to us a little late. I believe the third chair in was ready to carry the next bill. Is that right? So Representative Stivar?
No, this is a personal bill.
Oh, okay.
We killed the bill.
All right, all right.
Introduction.
Vice Chair O'Hearn, you want to help me tag team this one on the floor? All right, he weaseled his way out. All right, we are going to quickly move over to Senate File 96, Majority Whip. We're on a tight schedule, try to get through a couple additional bills, so if you wouldn't mind with brevity, we would appreciate it, sir.
Thank you, Mr. Chairman. I present to you Senate File 96. I know you're probably a little curious as to why a bill that deals with bankruptcy is before the Transportation Committee. I think the committee that normally handles things that deal with Title 13, which is which handles banking regulation, the workload's a little heavy. So I think they're trying to spread that out. But anyway, Mr. Chairman, if that's okay, we're going to start a little bit broad, why it's here, what it does, the need for it, that kind of stuff. So
Introduce yourself for me.
Mr. Chairman, my apologies. Cyrus Western, House District 51. So kind of the big picture context is this. Bankruptcy, obviously, with the exception of insurance companies, banks, and railroads, go through the federal bankruptcy process, Chapter 7, Chapter 11. We've all kind of heard some of those terms. Right now, there is a bankruptcy litigation that's currently pending in a federal court, I believe in Reno, Nevada, that deals with this type of issue. And so as the co-chair of our select committee on blockchain technology, this was something that we worked in the interim. And just to clarify, the reason that it doesn't say sponsored by blockchain is because all Title 13 legislation that originates in blockchain has to go through the Minerals Committee. The last Minerals Committee was before our last blockchain committee, so we end up having to run this as a personal bill. But it was one that we worked throughout the interim, had stakeholders involved. There was a subcommittee that Division of Banking was involved in, and I'm surprised they're not here. But anyway, it was one that we worked with them. They were on it. Commissioner Bishop was very closely involved in making sure that it was okay with him and that he didn't have any heartburn over it. So anyway, there's pending litigation at a bankruptcy court in Nevada right now. The question is this. Normally, so just to kind of use an analogy that's pretty easy, if I give, say Representative Stivar a piece of gold, a gold brick, and he's a financial institution, I say, I'm going to give this to you just so you are the custodian. That means you're not going to do anything with it, you're not going to invest it, you're not going to transfer it, any of that stuff. You're just going to hold on to that. The expectation, the agreement that we have is that, when the time comes, I can say, I would like that brick of gold back. There's a lot of bankruptcy law and case law in those bankruptcy courts that affirms this. In the case of digital assets, there's a little bit of a gray area, and that's why this legislation is here. Because basically what the court has, the federal bankruptcy judge has said, well, because of the nature of these digital assets, I'm not sure if this financial institution goes through bankruptcy, that you have to give this back, regardless of what the contractual agreement you may have signed is. There's a chance that when this financial institution is going through that process, that customer's assets might actually get kind of swept up in their bankruptcy proceedings. What this bill does is basically telling those federal bankruptcy courts saying, no, those assets belong to the customer, and throughout the entirety of those proceedings, when there's over, the customer may ask for those assets back. That's basically what this is saying. It's just saying, hey, if you follow these particular conditions, obviously, as outlined throughout the bill, that when you have to submit your balance sheets to these federal bankruptcy courts, these assets are isolated on their own and they are not commingled with the funds of the financial institution. That's basically what's going on here. So this is one we're trying to protect those customers' assets and their rights to their assets. Kind of that debtor-creditor relationship. Mr. Chairman, I know you guys have a heavy workload. Do you want me to go page by page or section by section, or how would you like to handle this, Mr. Chairman?
Vice Chair O'Hearn.
Thank you, Mr. Chairman. You mentioned contractual agreements. So I'm signing to give my gold bar to Representative Stivar. He's got to hold it for 6 months. That mean you can't come get it for 6 months? Because I'm going to loan money out, holding that gold bar for up to 6 months. Can you clarify that, please?
Representative Western.
Mr. Chairman, Representative Hearn, absolutely. It depends on the specific nature. And what's called a custodial relationship, you are telling that financial institution, say the Bank of Stivar, that you can only just hold this. You cannot turn around, make loans against it. You can't have it on your balance sheets, that when you have to report your financial statement to auditors, and all the auditing process they go through, that those assets, that gold bar is the property of this customer. It is in its own separate account and not commingled with the other assets of the institution. Because some of these financial institutions, they've got lots of different accounts. Some of those accounts, those funds are commingled from other different types of depositors. This is just when you have that agreement, and when a federal bankruptcy judge looks at these agreements, these trust agreements, usually it's trusts that are the financial institutions that we're referencing with that term, that those need to be isolated on their own, not commingled with the institution's assets, so that, making sure that these assets remain to that customer. And when the process is done, they get those assets back. Otherwise, they could be eligible for, when that trust owes a bunch of money to a bunch of other people, those assets that should be that customer's go to that creditor. So it's trying to make sure that your assets are yours and that they will remain that way. So, Mr. Chairman, so again, I know you got a heavy workload. How do you want me to handle this?
Representative Western, I think we will not task you with walking through the bill. This is a little outside our bailiwick. However, we still have the responsibility to make sure we're looking at our bills. I'm hoping you guys at least reviewed this. Are there any questions? Yes, Representative Berger.
Thank you, Mr. Chairman. Mr. Majority, Thank you. Is this happening in Wyoming? I'm assuming we're just protecting
Sure.
this preventative measures.
Mr. Chairman,
Representative Western.
Representative Berg, I think that's a great question. A lot of these trust companies are domiciled in Wyoming. So there's a lot of, I don't have the number off the top of my head, but there are dozens of what are called statutory trust companies that are incorporated and domiciled here in Wyoming. What this basically does is if that trust starts to go through bankruptcy or for whatever reason they have to enter bankruptcy, the immediate step is our banking division director is the conservator of that process before that the reins get handed off to the federal bankruptcy process. And this is simply saying that, as long as it is clearly stated in what's called a trust agreement, whenever one of these things is formed, it's kind of like an operating agreement with an LLC, that there's a certain types of relationships with that trust and their third-party financial institutions they may contract with to actually hold some of those financial assets. This just simply says that there's a defined relationship here and that those bankruptcy judges at the federal level will look at those relationships and say, okay, this is how it was clearly charted out in state law because property obviously is governed by the states. Federal bankruptcy courts judges generally look to what those states have on the books in the state where it's being litigated and where it was incorporated.
Okay, anything further? So Representative Western, you just made mention of it, and I want to check in with you on this. So anything that we have currently on the books, any of these trusts that have this information in here, if they're not currently held separate, if their contracts are not held separate, does this require them to go back in and renegotiate all of their property, or does this automatically take effect with any proceedings that may happen?
So, Mr. Chairman, so this, and normally it wouldn't be a problem at all, but because of the nature of these digital assets and in a process what's called staking, and I can obviously go into that, but this bill talks about it. So, on certain types of blockchains, like Ethereum, that's one of the big ones that's used. There are these what are called staking nodes, these different validators throughout this network that verify that this transaction is legitimate, it actually happened, and the other kind of information about the transaction. This just clarifies that despite this kind of going through some of these third-party vendors that are part of that staking process, that these assets are still property of the depositor and of the customer. It's just clarifying that. It's a little easier if I just say, here's a bunch of gold. I mean, you're the only custodian of that. It's only going to go through your hands. But by virtue of the way that some of these digital assets are managed in their nature, there's going to be other parties involved throughout that process of validation while you are still the custodian throughout that entire time. So.
Yes, Representative Obermueller.
Thank you, Mr. Chairman. So I'm just trying to learn a little bit about how this works. I put my money in the bank. I put my $500,000 in my local bank, and it's only insured for so much, right? I mean, why isn't this like that, where it's kind of an insurable sort of a risk with, it's, so there must be a situation in which these assets are commingled with others and used within the bank operation and invested and whatever they do with it. So we must be drawing some kind of distinction that way here. I'm just asking a question to teach me, I guess.
Representative Western.
Mr. Chairman, Mr. Obermueller, that's a great question. And I know we use the term bank in a colloquial sense, but legally, really big difference between a bank and a trust. It's certainly the case that's being litigated now that I mentioned, that's between a trust, where when a bank goes through the bankruptcy process, they're exempt from all the normal processes. Again, railroads, insurance companies, and banks. That's a little different. So if it's a bank that's the custodian of these assets, the FDIC comes in if they enter conservatorship or bankruptcy, and it's a whole different set of regs. This one, again, the most practical use case is with trusts, which again, if those go bankrupt, they go through the normal, Chapter 7, Chapter 9, Chapter 11 bankruptcy process. So, you're right. If you give $500,000 to a bank, a FDIC insured bank, those deposits are only insured up to $250,000, or maybe it's $300,000. But yeah. Whereas if you give this money to a trust, totally different set of contractual obligations and risks that both the depositor and the trust have in that asset. I mean, obviously, in the case of Ethereum or some of these other digital assets, the price of them fluctuates daily. But so there's that clear delineation between a trust and a bank.
Okay. Follow up?
So what your bill does is defines those lines a little sharper in terms of who owns what, or who owes who what?
Mr. Chairman, What this bill does is that in the event that those non-FDI insured institutions, AKA banks, who are entering these kind of custodial relationships with some of their third-party vendors. So the representative Obermuller Trust, I'm going to give you $1 million worth of Ethereum or ADA or one of those digital assets. As almost without exception, you're going to need other third-party vendors that you're going to be dealing with for the custodial services of that asset. Let's say, you go bankrupt and you have to go through this bankruptcy process. We're just simply saying that this bill is clearly defined in our trust, on our governing document of the trust, and your relationship to me as your customer, that when that goes through bankruptcy, the judge says, okay, these assets aren't being commingled, henceforth they are not eligible when you personally or your financial institution, your trust goes through bankruptcy. These can't be swept into that whole process and eligible for your debtor and your creditors to come after that. Just simply says, all these customer, digital coins, those aren't eligible for your creditors to go after. You have to pay that out of your own personal institutional funds. You can't pay your debts with my assets.
So committee, if you'll notice, this is, as the good majority whip has mentioned, this was a blockchain bill. Every single member of the blockchain committee was on this. I certainly trust a lot of the work that our committee has done. I also see that it's engrossed. If you wouldn't mind briefly touching on the changes that were adjusted from the, introduced to the engrossed version, and then we'll let you.
Sure. Yeah, Mr. Chairman, of course. And I was a pretty minor technical amendment. I think it was on page 9, I want to say. It had to deal with just, oh gosh, I just had this, Mr. Chairman, I'm a little embarrassed. Yeah, Senator Rothfuss down the other end of the hall. It was just changing transmitted to transmitter on page 9, line 9.
Okay.
Yeah, it was just that transmitted to transmitter. So it's a small technical correction.
Looking at everything here, as far as roll call and everything else, flew through the Senate. So committee, any further questions from the majority whip?
Question.
No. We got public comment. Okay. Representative Western, thank you.
Thank you, Mr. Chairman.
Have anybody from the state? Welcome to transportation. I'm guessing this might be your first time ever in front of this committee, so welcome.
Thank you, Mr. Chairman. Jeremiah Bishop, the Banking Commissioner for the state of Wyoming and head of the Division of Banking. Yep, I do believe this is the first time in front of this committee, so thank you for looking at this. I'll just do a little bit of overview again to kind of the process of a company failing, how we are involved, and then a few other things that this bill does. Representative Western did a very good job, I think, of explaining the overall purpose of this. But I'd like to start off with just going over very quickly, I know we're short on time, on how companies are basically handled if they fail. So we have banks, we have our SPDIs, and we have trust companies. Like was mentioned, banks are exempt from bankruptcy. So if they were to fail, our office would take receivership of that company. However, if it's a traditional bank, we return that over to the FDIC. They have a whole division. That's all they do is handle these banks. An SPDI is a bank under law, so it's also exempt from bankruptcy court. However, currently they're not FDIC insured. So there's no regulation by the FDIC. So if one of those were to fail, the division would take receivership of that company. It'd be up to us to wind that company down, either disperse those assets to the customers or basically find another institution to acquire the remaining assets. Trust companies, also similar, we are the only regulator of those companies. So if they were to fail, again, we would take receivership of those, of that company. And one of the amendments is how the options that I have. I can either wind that company down, disperse assets. If it's a traditional trust, I'd be charged with going through the courts and finding successor trustees for those trusts. But I also have the option of, instead of that, because that can be very costly, sending that to Chapter 11 bankruptcy court. So that is one of the changes. I think it's on page 9, is I already have that ability, but I think on page 9, it changes when I can do that. So right now, I can either take receivership or in lieu of that, turn it to bankruptcy. So it's kind of a one-time thing. I believe that change allows me to do it at any time. So I could maybe, if it's custodied assets, those might be simpler for me to return to customers. Maybe I could return those to customers and then turn it over to bankruptcy. So most of these changes, again, it really, I think Representative Obermuller had a good question of it just distinguishing who do these assets belong to. So these are, again, trust and custody assets. One of the questions was, how are these treated with bank insurance? These are different than your deposit account. A bank, you open your deposit, that is insured. These are not accounted for in that same way. They do not belong to the bank. That's through a trust account or a custody account. Let's make some definitional changes for that. And this bill makes it very clear that at no time do those assets belong to the company. So one of the, especially with digital assets, this is currently being tested due to some failures of other companies currently like in Nevada. And I think it was about a year and a half ago, there was a fairly major digital asset exchange came out and said, if you are our customer and we're custodying your digital assets and we were to fail, those assets don't belong to you. You're now an unsecured creditor. Obviously, that's a big problem. They were not the only ones in that case. Actually, every exchange, I think, is in that same manner. They just came out and said it. This bill protects that. If you are a trust company or a bank or an SPDI and you're providing these custody services, it's very clear that at no point in time do those assets belong to you. And if anything were to happen to that company, it must be returned to the customer. And that must be in the written agreement. And then our job as a regulator is to go in to review those agreements and make sure that that is happening. So that's generally what this does. Then there's various requirements for the agreements on different types of products. Another thing that this one does do that I'd like to cover very quickly, and this is on page 11. This is a change to our 3429-104. That's our the state's digital asset custody law. So currently, that really allows banks, if they are to offer digital asset custody services, must be in compliance with that section. However, trust companies, which are different types of entities, also provide these same services. And the existing language in that law does not require them to be in compliance. We also regulate both. So we'd like to, it's a good idea to hold the same standards to the same activity, regardless of whether it's a bank or trust company. So I think it is the new Q just says that if you're a trust company doing these services, you must also comply with the statute. And then we also have rules on digital asset custody. With that, I'd like to, if there's any questions, I know this is a new topic for you all, happy to.
The CPA has a question for you, Mr. Bishop.
Yeah, I'm just trying to learn, just to kind of teach me questions because this isn't an area of my expertise. But do the digital assets just get caught up in the bigger picture of other types of assets that go bad? Or, if you're my custodian for my digital assets and they're mine and I'm giving them to you, how do those get in trouble in your trust? Or do they just get caught up in a larger picture of other kind of assets being invested?
Mr. Bishop?
Thank you, Mr. Chairman. Representative Obermuller, sorry. Whether or not it's a digital asset, traditional asset, or any other kind of asset, the basic concept is the same. I'm custodying that asset on your behalf. It still belongs to you, but I'm just charged with maybe safekeeping, maybe accounting, various things that might be in that agreement. So whether or not it's getting into trouble, they're not going to be treated any differently than any other asset. However, they are somewhat novel and new. So how they're handled by the bankruptcy courts, I think, has been unclear. And I think that's one of the things that this is doing, is making it, just stating in state law that it is very clear how those assets are handled so that then the federal bankruptcy court can look at the state law.
Any further questions for the commissioner? Seeing none, thank you for being here. And again, welcome to transportation, which you'll probably never be back in front of, so.
Thank you.
Any further public testimony? Senator, nice of you to join us for your bill, sir. Good little bill. All right, we will close public testimony and bring it back to the dais committee. Moved by Berger, seconded by O'Hearn. I'm not going to walk through this. I feel like the Senate did a good job clearing that one little word up, and we don't have any concern from the banking division. So with that, is there any amendments to be had? You've got everybody glazed over here, boys, just so you're aware. Okay, question being called. Would you please call roll on Senate File 96 engrossed?
Representative Berger?
Aye.
Representative Nemec?
Aye.
Representative Obermuller?
Aye.
Representative O'Hearn?
Aye.
Representative Pendergraft has submitted an absentee vote of aye. Representative Smith?
Aye.
Representative Stivar?
Aye.
Representative Wiley? Chairman Brown?
Aye.
That's 9 ayes, do pass.
And Representative Western, I assume you'll be taking this? All right, we'll move on. Senator Cooper, you got two bills in front of us?
I wanted to run this.
Yeah, I'm sure you did, but it's a personal bill, too bad.
Mr. Chairman, can I introduce him?
Senator Cooper, I'm going to give you the pleasure of doing whichever bill you would like to do first, and you just have the floor with us, and we'll get going whichever way you would like to handle first, sir. Thank you for sticking around.
Thank you, Mr. Chairman. Ed Cooper, Senate District 20. We're going to start with Senate File 74, Special Districts, Reversal of Dissolution for Noncompliance. Give you a little background quick. First of all, after that last little bill, simple as it was, this is going to let your brains rest for just a second. This was brought to me by the County Commissioners Association. We're in a situation across the state where some special districts have, by the nature of them, have got a little bit lapse on getting their paperwork in on time, their reporting. A couple of them in my district went just past the first of the year. And by statute, if they go past that final deadline, they have to be dissolved. Well, in one case, it's the fire district, and that's something we kind of need around. But we've discovered that the county commissioners don't have the discretion to cease that dissolution. So what this bill does is just exactly that. If you look at the bill itself, it starts on page 3 and goes over onto page 4. And what it says is the Board of County Commissioners may, by resolution, reinstate a district or cease dissolution procedures required under subsection B. There are some requirements. The district has to be gotten themselves back in compliance. That's obvious. Before it can be reinstated, they've got to provide a corrective action plan to their commissioners, which I think is pretty necessary. And then also, they have to have verification from the Department of Audit that they are in compliance. And at that point, the county commissioners, if they so choose, may reinstate that they may cease dissolution, all right? So it also gives the county commissioners a little bit of discretion here. If this is a board they've had an ongoing problem with, the commissioners have the discretion to remove that board and appoint replacements to fill the vacancies. So that's the whole bill. That's everything we're talking about, just to give the county commissioners the discretion to cease dissolution once a board gets back in compliance. There's, I believe, 15 boards across the state, special districts that are in dissolution right now. Some of them want to be, a few of them don't. And probably if you look in a county near you, there's one or two that are going to fit right into this situation. So that's the whole bill, gentlemen.
Okay.
Stand for questions.
Senator, thank you. Committee, any questions for the good senator? No? I see none as well. This is a good little bill. So we'll go ahead and open this up. Since we heard the County Commissioners Association in here, and then I don't imagine there's any state party associated with this, so. Jeremiah, we're going to give you guys some more power? I don't know.
Good afternoon, Mr. Chairman, members of the committee. I'm Jeremiah Riemann here on behalf of the Wyoming County Commissioners Association. Appreciate your consideration of this legislation. About a month before the legislative session, I had one of my counties call me up and say, hey, we have a special district that has fallen into this dissolution process. And quite frankly, we're not too excited about the notion that we have to dissolve them because one, they provide a necessary service in our community, and two, these are duly elected officials. So we're a bit concerned about the position that we're being put in here. I said, well, I'm pretty certain there's a process by which you can stop dissolution procedures and allow that entity to move forward. And so we'll send you some information I got to digging into that. And the department had sent them some information about that process, which said once you've missed your filing deadline, you are now in dissolution. And there is no statute that allows for stopping that process. I came to the same conclusion that the department did. And so that's when I reached out to Senator Cooper to ask that we find some place here, a nice balance for when we find a special district that gets into this sticky space. Now, we don't want to reward bad special districts that get here on their own, but we want to find a good landing spot. So that's where we came up with this corrective action plan. And you can see there's also the provision in there that if the commissioners just think that this is a bad board and doesn't have the public's best interest in place, that they can reseat that board. They can identify new board members. So really appreciate this. It turns out it wasn't just one county. After we got to working on this, I got calls from Converse County, Fremont County, and certainly there are others that are facing this. And as the senator said, there are some districts that need to be dissolved, and the commissioners will follow through on their duties there. But in this instance, it's a fire district that provides good service. They were 3 days late. Now, I'm not going to make any excuses for them because the county did their part, the department did their part in notifying them. The district is at fault, but it's a needed service in the community. And so this is a good bill. If we can get it passed, the commissioners can work them out of dissolution, get that corrective action plan in place, and move forward. With that, Mr. Chairman, I'd stand for any questions.
Okay, committee, any questions for the county commissioners? Seeing none. I guess I have a question just on the management audit side of things. That's something that we have been dealing with similarly staking over the past couple of years.
Right.
This certainly intertwines with a couple of the other bills that we've seen, as far as those things go. So my concern is, if we have that many special districts that are starting to have this, what can we do? When I look at the commissioners that now have, if we grant this authority, this really does fall back onto you guys. What can we do to ensure that we're getting these special districts in compliance more often, as opposed to putting a burden back up on the county commissioners to decide whether or not they want to dissolve a board or not?
Yeah, Mr. Chairman, it's a great question. I certainly believe that the public officer training that's happening across this state, with its little warts and all, is a good thing and is going to help through this process. Obviously we've made some changes to withholding of funds. Money will speak to some of these entities, and that's appropriate, and the commissioners and counties have a role in that with special districts. The department through this, as well as the counties, I found are really following through on their responsibilities to notify these groups. Yes, we have a few that are falling through the cracks, but I've talked to the department too about, give us a notification. We'll work to try and be a part of that process and work with the Special Districts Association. I think all of these are part of the equation. I'm hopeful that we'll see less and less, but we'll continue to work with you if we can find other mechanisms to ensure that they're compliant. I just think this is a good way of, if they fall into a bad space, making sure that we set out procedures for how they're going to do it better next time.
All right, thank you, Jeremiah, appreciate it. Any further public testimony? Seeing none, we'll go ahead and close that. Senator Cooper, I noticed that you have Representative Winter. I noticed that he's not here, barring anything strange happening on this dais. Do you have somebody to carry this? Is he prepared to carry it, or?
I don't know if he's prepared or not.
Okay. I'll assign it to Representative Stivar. We'll just have him carry it for you then.
You want that?
Whatever works for you.
All right, committee, back to the dais here. What's your pleasure? Moved by O'Hearn, seconded by Nemec. Okay. All right, committee, any amendments? It looks like it came over very well written and agreed to over by from the Senate. Anything you want to put your fingerprints on and make this Senate file better? No? Okay. Go ahead and call roll on Senate File 74, please.
Okay, Representative Berger,
Aye.
Representative Nemec.
Aye.
Representative Obermueller,
Aye.
Representative O'Hearn,
Aye.
Representative Pendergraph has submitted an absentee vote of aye. Representative Smith,
Aye.
Representative Stivar,
No. Aye.
Okay, no, what is it? Okay.
Representative Wiley,
Aye.
Chairman Brown.
Aye.
That's 9 ayes, do pass.
All right, Senator, we'll get that one over and I'll back clean up if those two are not ready to tackle that one as well. So let's go ahead and move on to Senate File 89.
Thank you, Mr. Chairman. I'd like to introduce the gentleman from Department of Revenue, please.
Hi, Mr. Chairman. Ken Gill, Administrator, Property Tax Division, Wyoming Department of Revenue.
Thank you, Mr. Chairman. This bill came to me, I was having a discussion with a constituent who happens to be a vet, a pilot up in the northern part of the state. And as conversations do with constituents lately, it turned to property tax. And I asked him, did you apply for your veterans exemption? He said, yeah, I'll have $225 of it. And so I got to ask him about that and looking into it a little bit. The property or the veterans exemption program was put in place in 1949, right after World War II. And it was updated in 1957 to allow for $2,000 of assessed value to be exempt. $2,000 in 1957 assessed value, that was your house. That was a big deal. The last time it was updated was 2007, and that was changed from $2,000 to $3,000. Prior to that, there was an $800 lifetime cap on it, but that cap was removed in 2007. So what we've had for the last 17 years is that $3,000 exemption for veterans. I think our veterans are worth a little more than that. So what we've done with this bill is we've doubled that exemption to $6,000. That's the whole bill. That's exactly what we did. One thing we ran into, and the Department of Audit caught it, we had this originally going into effect in June of '25, and then we moved it back to June of '24 to help them out this year. But a lot of the veterans use this exemption for their vehicles. And so a lot of that exemption is already being claimed for this year, and it would have created a lot of heartburn, if you will, over as far as trying to implement it this year. So we moved the effective date to January 1st of 2025. And dollar-wise, what we're talking about on a $6,000 exemption comes to about $418, $19, something like that per year for our veterans. And I'm pretty proud to bring this bill in front of you, gentlemen. So with that, I'd ask for any questions or turn it over to the Department of Revenue.
Okay, committee, any questions for the senator? I'll just tell you, I'm mad at you that you didn't provide me an opportunity to co-sponsor. No, I'm just kidding. Ken, please.
Mr. Chairman, Ken Gill, Property Tax Division Administrator. Basically, from the department standpoint, we just have to look to whether it could be administered. And obviously, we're already administering this exemption, and this would just increase it from $3,000 to $6,000 assessed dollars. The good senator is correct in the history of this exemption. You're exempting 63,157 fair market value dollars. So you're you're exempting 63,000 approximately of fair market value on that property. Now, keeping in mind, not every veteran is eligible for this exemption. They have to have served during certain dates or have certain medals. So, and the good senator also mentioned that the veterans on this program can use it either on their real property, their home, their residential home that is their primary residence, or they can use it on their vehicle. So they save more on the home, but they can use it on the vehicle also. So, and not to be confused with the disabled veteran license plate. That is not this program. That is a separate program. So with that, I would stand for any questions, but it can be administered. It can be administered very easily. There's 3 calendars in property tax. You have the tax year, which is January 1 through December 31st. You have the fiscal year, which is the typical fiscal year, July through June. And then you have the Veterans Exemption calendar, which is the 4th Monday in May to the 4th Monday in May. So the good senator is correct. It would be in effect for the 25 year. So starting on the 4th Wednesday of this May coming, veterans could start using it on their automobiles from the 4th Wednesday in this May through the 4th Monday in May 2025 for the 2025 tax year. So I know it gets a little confusing with those calendars, but they will be able to start applying this in 2024, just not on the real property.
Okay.
Mr. Chairman?
Yes.
One little thing to add, it's my understanding that this can be stacked with our other exemptions. As we're going through these property tax exemptions that are coming, there may be some limits on how many exemptions people can apply for, but this exemption can be stacked with our other exemptions. So this is a real special thing for our veterans.
Representative Stivar, please.
Thank you, Mr. Chairman. I'm going to be a conflict on this because I am in this program. The question I have is, I know we backfill the counties for these exemptions. What's that increase going to be?
Mr. Chairman, good question, Representative. Currently, when you look at this program and historically, it's about $3.9 to $4.1 million per year, and it's steady. We lose veterans, sadly, on a yearly basis, but we gain veterans that sign up for it. So it stays pretty steady, right at that $4.1 million. So it would just double it. It would be $8.2 million total per year.
Committee, anything further? Okay. All right, thank you, gentlemen. We'll call for public comment. Chris, do you have some notes from the military department for us? Or are you speaking to us on a personal favor here?
Mr. Chairman, Chris Smith from the Wyoming Military Department. I'm actually appearing on behalf of the Wyoming Veterans Commission. Executive Director Tim Shepard sends his regrets to not be here. The Secretary of the Veterans Administration is in the state this week. He's touring the northern part of the state with him, so he couldn't be here. The Veterans Commission is very much supportive of this and is very thankful to Senator Cooper for bringing this. In my prior life, I actually was around in 2007, had a hand in drafting the changes. One of the changes we made back then was it named specific wars, going all the way back to the Indian Wars, believe it or not, in the statute, in Section A, which is not in front of you. And at that time in 2007, we tried to fix it so that it wouldn't have to be amended every time there's a new conflict. So if there's a campaign or exhibitionary medal, it would apply. It also applies to disabled veterans, but only if they actually have a VA rating. So there's approximately 47,000 veterans in Wyoming, more than you expect. Many of them are sitting on the committee. This applies to about 16,000 veterans currently. So it's a little less than a third of the actual veterans out there. As was mentioned by the previous testimony, it hasn't been changed in 17 years. You all have heard this session repeatedly, lots of testimony and discussion on what's happened with appraised values in most of our counties in Wyoming. Compared to 2007, average house prices were under $200,000 in Laramie County in 2007, and now they're about $350,000. So there's almost doubled. And so this is a great thing for our veterans. There is a cost to it, but as always, the legislature has been extremely supportive of our veterans and is very much appreciated. So with that, I will certainly stand for any questions the committee may have for me.
Committee, any questions for Colonel Smith? So I've got one. You will remember when 2017, 2018, coming in here, we had a lot of stuff on the chopping block to start coming after some of these exemptions and these benefits. I guess my question is on this, when we start adding this out there, is there communication that this is certainly a privilege that we love to share when times are good and we have the money right now? Is there communication that goes out to the veterans out there from the commission that if times get rough, we may not be able to afford this again? Something like that, and especially if we're upping this. I mean, I always sound like a jerk when I'm talking to my dad, who's a veteran, right? That, this is a privilege. It's not a guaranteed benefit, and we can take it back anytime if we have to. And so I guess my curiosity out of this is if we double this, what does that look like to the veterans who depend on this?
Mr. Chairman, I mean, obviously, as the testimony before the House and the Senate has been this year about property taxes in general, many of our veterans are on a fixed income between their retirement or disability plus Social Security. Property taxes is probably one of their biggest bills. So it is very much appreciated that this exemption helps a little bit, a couple $100 a year into their pocket. We changed to $400 a year. The Veterans Commission regularly updates veterans if they sign up for the various newsletters. And as our experience through the 1920 budget crisis, I will call it. Some of you may not be able to call it that, but I'll call it that. And yeah, things can be cut, and we know that. The military department is well aware. We used to reimburse for SGLI, the life insurance program. That's still on the books, but it's unfunded. We haven't done that in years. We've cut some of the retirement contributions for emergency workers who go on orders. So we're well aware of that, and it is out there. Unfortunately, of course, veterans rely on this. You can't keep that from happening.
Okay, I appreciate that, and that's exactly what I was looking for. It's just that we do talk about it, and it was a tough part. So I don't think there's any. Oh nope, Jerry was here when we were going through that. That first year in here for me was a very, very difficult time frame because everything was on the block. So I appreciate it, Chris. Thank you.
I remember it well, sir.
Yeah. Any other further public comment? Anybody online? Okay. Ken, I have a quick question for you related to, you mentioned the vehicle usage on this. Can you just explain how that works differentially? If somebody claims $10,000 or $5,000, but if they get the $3,000, how does that affect their vehicle registration versus what we have on the house?
Sure, Mr. Chairman, that's a great question. So it's multiplied by 3 mils. So in essence, it's $90 on their vehicle registration.
Perfect. Thank you. Yep. So Representative Berger?
The $6,000 in exemptions is $90 or?
No, Mr. Chairman, currently the 3,000 is $90, the 3,000 assessed.
Okay,
Please.
Mr. Chairman. Okay, so then another question. What if we up it to 6 and I say, okay, I want to use 3,000 for my vehicle and then 3,000 exemption for my property taxes? Can you do that split, or is it one or the other?
Mr. Gill?
Mr. Chairman, typically it's one or the other, but not always. Sometimes there are properties that fall below that $3,000 threshold. So they'll use it on their property first, and there may be a little remainder to use on their vehicle. So, and that happens statewide. It doesn't happen a lot, but there are instances where that does happen, or sometimes it's used on the, let's say, a lower valued home and then the land, so.
Committee, any further questions? Okay, we'll close public comment, bring it up to the dais. Committee, what's your pleasure? Okay, moved by Berger and seconded by Nemec. Committee, we'll run through this one fairly quickly. Any Any changes to page 1? Okay, nobody else will make the motion. I will. I did some quick pricing here. So the $3,000 was put in 2007. $3,000 at that point would be worth, oh, bear with me here, would be worth only about $44.62. Now, but it took us 17 years to get to that point, right? So we're just now starting to catch up with this. We're a little inflationary adjusted on this. I'm actually going to make a motion, we'll see what anybody says, to take this to 10,000 and inflationary proof this for the going front, and then we'll work this out with appropriations to get the appropriation to the correct amount. So that's my motion. Seconded by Berger. Discussion.
No.
No? You can still talk.
Yeah, please.
Okay. Committee, any further discussion? Representative Obermueller.
Thank you, Mr. Chairman. Just curious to what year as the 6,000 gets us to? And if we do that, that's clearly forward-looking to what point?
So I'm doing this on the fly, Representative Obermueller, but average dollar inflation rate is 2.36%. So that's going to take us out probably another 20 years before this has to come back before this committee. So yeah, it does inflationary proof us.
Yeah, I think I'd be opposed to adjusting the 6,000 just because of the, if we make that amendment, that's going to be a big debate on the floor. If somebody here wants to bring it after they've analyzed it further, but for now, I'll be against it.
Fair enough. Any further discussion? Okay, all those in favor of amending 6,000 to 10,000, go ahead and signify by saying aye. Aye. All those opposed? No. Let's do a show of hands just to make sure. I think it passes, but signify by raising your hand. Aye. So I've got 1, 2, 3, 4. So no, it does not. Ooh, it fails because we don't have our tiebreaker here. So that's okay. Committee, anything further?
Bring it back in a minute.
That's right. All right.
That was my question.
Seeing none. Diana, if you'd please call roll on Senate File 89 engrossed.
Representative Berger,
Aye.
Representative Nemec,
Aye.
Representative Obermueller,
Aye.
Representative O'Hearn,
Conflict?
Representative Pendergraph has submitted an absentee vote of conflict. Representative Smith,
Aye.
Representative Stivar,
Conflict.
Representative Wiley,
Aye.
Chairman Brown.
Aye. And just for the, oh, I'm sorry, Diana.
That's 6 ayes, 3 conflicts, and do pass.
Okay. And just for public, anybody who is listening, as well as anybody that's in here, the conflict votes do count as technically as a no vote if we were to be in a tie or anything like that. It is also expressly written in our statutes that conflict is only necessary if you don't represent a larger class of your constituency. In this case, you're representing the 50,000+ veterans, so you don't have to, but I appreciate the noted conflict by the 2 members, actually 3 members on this committee. Understand where you're coming from completely. I just want to make sure that the general public understands where we're coming from. So with that, we are adjourned.